The sexual harassment bill by the Nigerian Senate has met with very stiff resistance by the Nigerian lecturers. According to them, the bill is targeted at trampling on their human rights, as they describe it as sheer proliferation and repetition of legislation. The bill, which has since scaled second reading with 27 clauses, proposes up to 14 years jail term with a minimum of 5 years, without an option of fine for any educator who commits sexual offences in tertiary institutions. Now, joining us in the studio to discuss this is a lawyer, Barrister Prince Uzeme. Good morning and thanks for joining us on the show.
Good morning.
Good morning. Thank you for joining us, Barrister. Now, it's interesting to note this sexual harassment bill. It's something that we've been speaking about all morning, but it's actually something we've been speaking about for the last few months. And this is as a result of BBC journalist Kiki Mordi bringing out this documentary, if you will, a private eye, bird's eye documentary on what's taking place in Nigerian universities. Now, with regards to the sexual harassment bill itself, why do you think so many Nigerian lecturers feel entitled enough to state that their human rights are being contravened, as opposed to the human rights of the students who are actually bringing up these allegations?
Oh, well, personally, I want to call this the curious case of the Nigerian lecturers who seem intent on eating up their tail. It's just like a case of a particular office where there have been so many cases of theft. Let's say phone theft, and so many phones have been missing. And everybody complains in the office that our phones get missing. Then one day, the management of the office says that, okay, we are going to have CCTV cameras. And in this section where the phones are being stolen, and somebody comes out to say the CCTV camera is an invasion of my personal human rights. That, for me, doesn't make any sense. Exactly. It is like turning the law on its head for Nigerian lecturers to come out to say that in their institution, where there has been so many cases of sexual harassment, so many cases of bordering or on infringement on the sexual rights, the fundamental rights of their students, where the government says that at last, let's do something specifically targeted at cleaning up the rot or the mess in these places. And the lecturers, the trade union of the universities, the academic staff union of universities, ASU, that I expect should be at the forefront of telling the government that well done for what you are doing, for telling National Assembly that yes, what you are doing is beautiful, but can we make the bill more robust in this way so that we can actually target, it can actually achieve the results that it was meant to achieve. Instead of the trade union, the lecturers' body, to say that the lecturers' body is coming out to make these infantile arguments, these inane arguments, to say that their human rights and their privacy is being infringed upon. They are saying things like the sanctity or the credibility of the certificates that they are issuing out would be eroded by this bill. For me, it makes no sense whatsoever. For me, it only raises the question to start asking that, could the guilty people that we are seeking to fish out with this bill, could they be among this trade union, the ASU, that is now coming out to rebel or to fight against the law that is meant to clean their audience tables? For me, it makes the ASU to look very bad. I would advise them from this point that they should drop those arguments that they are making, but because those arguments don't make any sense. Now, the only thing that I would say made some sense in what they said was that why is the bill being targeted only at Nigerian universities when the sexual offenses permeate the various industries, be it accounting, where different workplaces we have sexual offenses. Now, if they were making that argument, I would understand. I would say, oh, okay, National Assembly, let's look at expanding the scope of this bill to include those other industries, or those other areas that the bill presently doesn't capture. Making that argument, I would state that there is nothing wrong with a bill that specifically targets the tertiary institutions. All over the world, there are bills that, there are laws that target specific institutions. There's nothing wrong with that. You could say, oh, after this bill targeting specifically the tertiary institutions, going forward, we can also have other laws that also deal with sexual harassment in other workplaces.
But it makes you wonder exactly what the lecturers and the academic staff union is afraid of with this law coming into place. Exactly what are they, afraid of? They have said there is a proliferation, if this bill, does become law, that there are other laws that could actually take care of, such situations. In the case of the Unilag lecturer, for example, who's been sentenced to 20-something years, I mean, isn't that...
Professor Richard?
Yes, exactly. And that's the Ife lecturer.
Yes.
And the Unilag lecturer that just backed about 2 decades. Yes. Mm-hmm.
Now, I want to state here that what the lecturers seem to be afraid of is that they seem to they are trying to protect their space. Now, they've been operating this way for decades. In Nigerian universities, anybody that has passed through a Nigerian university knows the appalling cases of sexual harassment that goes on in the Nigerian universities. We have cases where students get to spill over, fail courses, just because of a lecturer has told them point blank that except you submit to my advances, you are not graduating from this university. So what I think ASU is afraid of is that they want to protect their space where they've been maintaining the status quo of continuing with these practices and getting away with it. We know that most times when cases of sexual harassment get reported in our universities, what ASU does is that they gang up and they protect their own. And when these cases come out, you hear grumblings from ASU, like this should have been dealt with internally, that there are internal measures set up by the universities to deal with them. What we are saying is that whatever internal measures that ASU or the universities have set up are not either adequate or they are not being adhered to. And since they are not being adhered to, we need something that could allow the external bodies, the external law enforcement agencies to also be able to bring these perpetrators to book. So what I think ASU is afraid of is that they are simply being territorial and they want to maintain their powers and proceed the way they've always been going, which I think we should speak against.
I'm happy you mentioned power there, because that's a really crucial tenet when it comes to sexual harassment and sexual abuse. For a victim of sexual abuse to even voice that they have been targeted, that they've had to have sex against their will because they can graduate, the strength it takes to do that is so huge. And you can understand that in as much as we are women here, educated, gainfully employed, we enjoy privileges that some people just don't. So if you have the situation of tertiary institutions, people at university perhaps being the first one to go, we have to be able to change the narrative behind it. So if we can say these bills, should they become laws, they are here to protect you, I wonder if you think that they will be a viable deterrent, because in order for them to be exercised, somebody has to be able to report what's happened to them. And I don't know if the framework is there for people to feel safe enough to be able to do it. Because if a student says, this lecturer, I've had to sleep with him against my will, and whatever happens to that lecturer, what happens to that student in the school? Because that's just one fish in a sea full of piranhas. I just wonder if, even if 15 years is a steep term or not, I just wonder if that's going to do enough to address the issue, which is men in power abusing that power to the detriment of female students, to the detriment of students.
Yeah, I want to state here that what this bill, the challenge that this bill is going to face going forward when it becomes a law is a problem of enforcement. Not just enforcement, but the personnel behind this, the enforcement, and also the public perceptions. We know, I will state it here, that our society is patriarchal in nature. It is structured in such a way that when it is difficult for the female who has been harassed to come out to say, I have been harassed or I have been sexually molested, because we exist in a society that takes pride in going after other irrelevant issues, like how was she dressed, how did she approach this person that she's accusing of harassment, all of that. Nobody comes to look at the fact that what exactly happened here. What is the trauma that this person is passing through at this moment? That is why I've come to the conclusion that our society is irredeemably patriarchal, and because of that, that is a challenge that this law is going to have, because it is not enough to just have laws out there that says that, oh, no more sexual harassment, or when sexual harassment occur, that this is a punishment. We still need a population that has been oriented. We still need lecturers. We still need the management of the university that have been oriented to first cater for the victim, to first protect the victim before looking at the circumstances or whatever the victim may whatever contributory circumstances that the victim may have engaged in. We all know that the relationship in the university, same way relationship across board, is a fiduciary relationship, a relationship where the lecturer is placed in a position of trust and care. The lecturer owes a duty of care to the student. So we do not want to hear inane arguments like is the student that seduced the lecturer, or that the student consented to this act. That is irrelevant. Because this should be a strict liability offense. What that means is that if a lecturer that has been placed in that position of fiduciary trust and care over the student is found to have engaged in these practices with the student, automatically, whether it is consensual or not, whether the student seduced that lecturer or not, those should be irrelevant considerations. What should only happen is that the lecturer should go down, because what happened was that you were placed in a position above this student. This student is supposed to look, you are supposed to be in loco parentis to this student, to be in a position where you are like the parent of the student outside the student's home. Yeah. So you cannot come back to say that the student seduced me. So what I think is a problem is that beyond this law, there needs to be a total overhaul, a total reorientation of the way we see sexual offenses, the way we see sexual harassment, vis-a-vis the place of the female in the Nigerian society.
Okay.
Now, Barrister Prince Uzeme, it's interesting that you mention all these points because it's something that we wholeheartedly believe in. But let's play devil's advocate for a moment. Let's assume the head of ASU came out to say, okay, well, you shouldn't just be targeting universities, you should target all workplaces. In an average workplace, you have an HR director, you've got an HR human resources department that you can report any violations that take place within the office to. Number one, who do these students have to report to in a university, in a tertiary institution establishment? That's my first question. My second question is, with regards to you mentioning the fact that these students should, some of them come onto the lectures, if you will, the fact of the matter remains that these students are very vulnerable. You know, in any other situation, whether it was in the workplace, it could be a consensual relationship. Absolutely. Perhaps the woman came onto the man. But regardless of the situation, in these tertiary institutions, as you mentioned, these lecturers are supposed to be in locus parentis. Yes. So these students are the most vulnerable. Is that not the reason why this bill should be passed without any further debate on the matter?
Like you correctly stated, there shouldn't be any further debate on this matter. Now, as to your question as to where can the students report these offences to? The incoming bill that is presently being considered has a provision in sections 15, 16, and 17 that states that every university would be, every higher institution, every tertiary institution would be expected to set up an independent sexual offences prohibition committee that will be consisted of 7 members. Headed by a senior lecturer, and the students should be able, will be able to make sexual harassment representations to this committee. And there has been a laid down procedure from the moment this complaint is received by the committee, or to its investigation, to its findings, and reporting its findings to the highest, for example, the vice chancellor of the university. All of this has been laid down. But if I were to come into this bill, I will state that there's still a lacuna, a sort of gap in the bill, because I didn't see where, after the independent sexual offences prohibition committee makes these recommendations to either the vice chancellor or the rector, as the case may be, there is no clear provision between this step and the law enforcement agencies. At what point?
Barrister Prince, we do have to go for a short break. We're all very impassioned about this topic, so we will continue this after the break. Do stay with us. Welcome back to the morning show here on Arise News. Now, we are still joined in studio by lawyer barrister Prince Uzeme, who's talking about the sexual harassment bill that is to pass or recently passed in Senate. Now, tell us more about your thoughts that you were sharing prior to going on the break.
My thoughts on this bill and the pervading atmosphere, as in with concerns with relation to the public perception of sexual harassment by the Nigerian society, is that there's a whole lot that we still need to do. Let me tell you where we need to get to. We need to get to the point where a man, for example, invites a female to his hotel room with the intention by both parties to have sex. And when the female gets to the hotel room just before the consummation of the act, the female changes her mind and says, no, I am no longer interested in this. I don't want this anymore. We should get to the point where the man should know that the consent that was there initially has been withdrawn. And when that consent has been withdrawn, the man is stopped from proceeding further with that activity. But what we have in Nigeria today is that the public, instead of looking at was there consent or not, what kind of relationship was there between these two persons, the public goes into irrelevant issues like what was she wearing, what was she doing in his hotel room, how did she get in the first place. That is not where we need to be. In responsible crimes, where the issue of sexual harassment is on the front burner, this is the way it is treated. Consent can be withdrawn at any time, and nobody should bring in the issues of, oh, what was she wearing, or how did she get there? Yes. So I think that the sexual harassment bill, even though commendable as it is, I think it's a great step. But I think it still has some way to go to get Nigeria to where it should be.
I'm glad you actually say that it is a great step, but it still has a long way to go. But let us even look at the factors that, you know, allow for this kind of situation to actually happen within the university system. Beyond this law, how about looking at the university system itself to plug those loopholes that allow for this to happen? And again, is this law, if it comes, you know, becomes reality, is it open to abuse? Where, you know, you could have a situation where a female, or even a male for that matter, wants to discredit a lecturer, which is one of the arguments that ASU is putting forward.
Well, then it goes to trial, doesn't it?
So what do you do in that, you know, situation?
Let me state, first of all, that my comments about the female also include the male.
Apply to the male.
Also apply to the male. That's the first thing I want to state here. I only took the female as a case study. Now, concerning the situation in the universities, we have a situation where the lecturers, rightly so, have a lot of powers with respect to their treatment of students, their marking of examination scripts, and the passing of students. They have a lot of powers, and most of the time there is no review of their decisions concerning a student. So what we are saying is that yes, generally lecturers should be able to assess and to the best of their judgment pass or fail a student. But when the student feels that he has been discriminated against in any way, either sexually or not, there should be a forum, a clear and defined forum that the student should be able to make complaints, and the forum should be able to look at that complaint dispassionately and without all these irrelevant considerations that we go into. Now, your second question, as per
whether it is open to abuse, if this bill actually becomes law.
It is open to abuse, because when we have a right, we also have a left. It is open to abuse in the sense that unscrupulous students could take advantage of the law to make unfounded allegations. That risk is always there. But when, because there's a risk, does not mean that there should be no law. So the law, the proposed sexual offences bill also proposes that where a student is found to have made an unfounded allegation, that student should be suspended and in some cases expelled, according to the recommendation of the Anti-Sexual Offences Prohibition Committee. Now, I think that is too small. That is too little, because let's put things in perspective. For where a lecturer commits a sexual harassment offense, the lecturer will be prosecuted considered in the High Court as in an external place. An external agency looks into the case. But the bill is saying that where a student is found to have made an unfounded allegation, the school will consider it internally. I don't think that is full enough. I think the bill should have gone beyond that. But the only thing that I also want to say again is the problem of subjectivity. Because who decides that an allegation is unfounded? We need to understand when it comes to sexual offenses, most of the time there is no real evidence. Somebody says that as I was passing, he touched me. I mean, or he touched me or she touched me.
How do you prove that?
How do you prove that? So the law needs to go beyond the simplistic way that it is at the moment and look at possibly, let's go to other crimes, let's go to other countries and see how those other countries have treated these issues. It is difficult, as a lawyer I can tell you from here, that it is difficult in most times to provide hard evidence for sexual allegations. The allegation has happened, but there is really no way for you to prove it. So the law must also put in place the ability to consider extenuating circumstances or the track record of the person being accused. What has been the track record of this person being accused, that is being accused at the moment, as with respect to either...
Do they have a history?
Does the person have a history of all of this? And we should also go as far as having a sexual offenders register that would...
That's what I was going to ask.
Yes, a sexual offenders register that would ensure that people like that do not get employed in places where they hold a fiduciary relationship, a relationship of trust and care over those looking up to them.
Absolutely. Now, do you have a further question to ask?
I do. I was going to ask about, your ideas behind ways we can, enforce these types of issues with the sex offenders register. Another question I do want to ask, though, is what are your opinions about how? I know you've touched on it already, but how do you think society views harassment? Do you think it's been normalized? Do you think girls are growing up with the expectation that often, you might go to a supermarket, somebody might give you a compliment? How do you think that girls should be able to readily identify this is something I should be concerned about or this is something I should not be concerned about? There, as you've said, the lines aren't always so clear. Even during the Sex for Grace documentary, it wasn't always, oh, you come to my room, this is what we're going to have. It's always the nuances of conversation. That one makes it difficult for these laws to be enforced, makes it difficult for cases to be found if, in fact, there has been sexual harassment going on. So what do you think, where do you think people will get the information to be able to readily identify this is wrong, and it's wrong for X, Y, Z reasons?
Well, if it makes you uncomfortable, it's wrong. It's boundaries.
But is it illegal then? Do you understand?
That's another question.
Does that make it illegal?
Yeah. I want to state here that when it comes to issues of sexual offenses, you have to look at the intent behind the act. One action could be legal, and in another instance, the same action could be illegal. What that means is that if, for example, my friend comes to me and I tell the person, you look good, I like your skirt or whatever. The intent behind that statement for me is important. We could be friends. We could be friends, or you've given me the consent to do all of that. But when we are total strangers, and I walk into your office, either you're my lecturer or you're my boss in the office, and the first thing you're telling me is that you look sexy or you look hot. Now, these two situations contain basically the same statements, but the intent behind the actions is what makes one to be non-sexual harassment and makes the other to be sexual harassment. So where a victim has complained that I didn't like the way my boss spoke to me, or the suggestive manner, or the inferences that my boss made, that should automatically be termed to be sexual harassment. So let's not, it is, like I said earlier, it is not a hard and fast thing. It goes beyond to what we in law call a mens rea, as in the mental element, the intent behind that action. So it is not enough to say that somebody was invited to an inappropriate place. Now, the person could have been invited to that place that is deemed inappropriate to discuss business, like one of you suggested the other time. But it could also have been, the person could also have been invited there just to harass the person or to make the person feel uncomfortable. Now the bill has gone as far as talking about touch, sexual intercourse, as far as a wink. A wink has been classified as a sexual harassment offense in the proposed bill. Now, you know very well that two of you could be in the office and you wink at her in the course of a conversation or in the course of a laughter. That doesn't constitute, that shouldn't constitute sexual harassment.
But again, like you said, it goes back to intent.
It could be
the two of us not beginning. It's not sexual.
Yeah, the same action could be read to mean that the wink you gave to me was like communicating a sexual an intention. So that could be attempt to be sexual harassment. So my point is that there is no hard and fast rule. Like we say in law, every case will be treated on its own merits.
Is 14 years enough deterrent?
Well, the law has specified basically, primarily, prison term of between 5 years and 14 years. And in another case, between 2 years and 5 years, depending on the severity of the offense. I think placing that 14 years vis-a-vis, as in pari passu with other offenses like murder, like kidnapping, like stealing, and all of that, I think the 14 years is an adequate punishment for sexual offenses, depending on the level, the gravity or the severity of that offense. You will agree with me that you are not going to compare or place rape on the same place as you want to place an inappropriate word spoken to someone. So if the person that raped someone is going to go to jail for 14 years, the one that spoke inappropriately to the victim cannot also have the same 14 years. That's why the prison term is graduated from between 2 at the lowest instance to 14 years. So I think it is adequate when compared to other offenses in our criminal code.
And we are running out of time. We've got about a minute left. But I do want to touch on something that you mentioned earlier, and that is how things are done in other climes. Now, you spoke about how do we monitor things in these institutions, but if you look at some of these schools, they have CCTV abounding so that they can see what has taken place. Now, we have unfortunately run out of time, but I think that's a great place to end. The fact that it all really boils down to infrastructure at the end of the day.